Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, we are going to talk about what is referred to as writ of mandates. Now, let me pose the situation first so you'll have a better idea of what a writ of mandate is. You file, for example, an adjustment. You go to the interview and they seem to say everything's fine, and you end up waiting a year, 2 years, even longer. And when you go back, every time you go back to get a status check, they say, well, there was something going on with the fingerprints and we're following up on it and it's in processing. Or what happens is you apply for naturalization. You pass the test, you answer all the questions, you show no criminal history, and they say you passed, and then you don't get your appointment for the swearing-in ceremony, and you call to get status or get an info pass appointment, and sure enough they say it's in processing, or they're following up on something, or there was some match on some database name that they need to follow up on, and years pass and nothing happens. Or you're doing consulate processing, wanting to bring your spouse over, and let's say your spouse is from a country such as Pakistan, or has a name of Muhammad or whatever it is, and again, it's held up at the consulate. No specific reason given, no denial, no approval. They just say it's in processing and waiting, or a myriad of other situations where essentially you have filed what you need to, you have done what you need to, you have given them everything they asked for, there's nothing pending for you to do, yet you still don't have an answer. Well, in these particular cases, there is what is known as the writ of mandate. And what the writ of mandate does is it is a lawsuit that is filed against the entity that will make the decision. So it could be a whole variety. I mean, it could be USCIS, it could be Department of State if it's at the consulate, it could be the naturalization office. There's a wide variety. Even if it's outside the country at a U.S. consulate, you're able to do this. And the purpose of a writ of mandate is so that what you're asking for is you're asking the judge to force the government to make a decision. Okay, you're not necessarily asking them to make a positive decision, because they might say no, but you are forcing them to make a decision, because the reality is if they're going to deny it, at least you have a denial and you can either appeal or do a motion to reopen or follow up on some other option. You know what you have. But in the vast majority of times, it's not even going to result in a denial. It would result in an approval, because there's no basis for them to be holding on to the petition for this long. I mean, when you think about it, if this was a high-profile case and there was some database similarity to the name that flagged something, I guarantee you within 5 hours they would have all the information they need to know whether there's a real security risk to the United States or whether there's a real issue. It wouldn't take 2 years and 3 years and so forth. And so the writ of mandate is the perfect tool, because when you file something, there's a legal obligation that they have to adjudicate it. Again, there's not a legal obligation they have to say yes, but there is a legal obligation to adjudicate it, to rule on it, and to make a decision on it. You have a right to know. You don't have to be sitting there forever wondering when they're going to make the decision. And I have a lot of people ask me, they go, well, if you sue immigration, are they going to get mad? And the answer is no. I mean, you have a right, and if you do it and it's done correctly, then what happens is they get on the ball and they do what they need to do. Now, let me tell you procedurally what happens, and I would suspect of all the writ of mandates I've done, this has been the procedure on about 95% of them. first we send the demand letter, which they never respond to. The demand letter is, please adjudicate this matter within the next 10 days, or we will file a writ of mandate. And they have nothing to force them to do anything at that point. So then I immediately have prepared the writ of mandate, and the reality is I have the writ of mandate prepared before I send the demand letter, just from experience, because I know they're not going to respond to it. And then we get the writ of mandate filed. Now, once the writ of mandate filed is in court, then the government, or the entity that you filed against, then will have 60 days in which to answer that legally in court. Now, just think about it. What are they going to say? Are they going to say, well, it's going to take us more time to adjudicate this case, when it's already been there for 2 years or 3 years and it's been sitting on some desk somewhere with nothing being done on it? This is what happens. The U.S. attorney who gets the case from the government, normally I'll get a call on the 55th or 56th day or something like that, and they'll basically say, look, what do we have to do to make this case go away? I'll say, well, adjudicate it. Tell your client, the U.S. government, to give us a decision. And I go on with my normal thing. I go, look, you're going to have to stand in front of the U.S. judge and explain why your client has not done anything on this case for 2.5 years or 3 years, and why that is going to, why that's going to stall everything that's going forward. So in that particular case, then what happens is I'll usually get a request from the U.S. Attorney, well, can you give me, 30 days extension, and I'll see what I can work out with my client. And then, normally the first extension I'll give without any problems at all. And then what will happen is on the 29th day before it's due, or like right before the deadline, all of a sudden the case is adjudicated. We get many times an approval in the mail. We get sometimes a request for evidence saying, well, we need a little more information on this or that. And then magically the case goes away. And then I get a follow-up email/call from the U.S. Attorney, let's dismiss this case now since it's been adjudicated. And boom, we never had to go in front of the U.S. judge. The U.S. Attorney never had to try to explain why nothing's been done for 2 years. It is a great tool to use to get done what needs to be done. Now, it's not easy to prepare the writ of mandate, obviously. It takes a lot of work, and that's why they know, they being the government, that unless you're real serious about doing it, they don't have any pressure to essentially roll over and adjudicate the case. And that's why you need to make sure that if the threat of doing the writ of mandate is done, it must be done, because they'll never take you seriously again. I know that some attorneys will make that threat, and then, assuming nothing happens, it just stops at that point. And of course, you don't want that to happen. So when you're separated from your spouse and your family, and when you're just in limbo time after time after time, it's time to do the formal inquiry, and then to do the writ of mandate. That is the key to getting done what you need done, and to processing the case so you can move forward. Don't be afraid to do it. My office does writ of mandates all over the United States, and the reality is that it doesn't get them mad at you. It gets them to move and do what they need to do. Now, I won't file a writ of mandate if I know that the case is very weak, and that most likely a denial would come. Then I have to look at a case-by-case basis as to what might happen with that denial. But for the most part, if you've just been waiting and the case is approvable, then the writ of mandate's the way to go. So give my office a call. Send me off an email. See what can be done, and I'll give you some specifics. And the initial consultation's free, and then we'll go from there. And if we need to go forward and do a writ of mandate, it certainly is a possibility. Now, just so you know, whenever I file a writ of mandate, I also file what's called EJA a request for EJA fees, and essentially if the court finds that essentially immigration acted in a manner that was not proper, that they delayed in a manner that was not proper, they will reimburse 100% of the attorney's fees that you pay. Now, obviously, I can't guarantee that, and sometimes it doesn't happen, but I certainly ask for it. So give me a call, give me an email, and then we'll go from there. More on the coming videos.